Hello and welcome to LiveLaw Daily. I'm your host Debojit Das. Today, July 30th, marks both the International Day of Friendship and the World Day Against Trafficking in Persons. One reminding us of the importance of trust and cooperation, and other highlighting the need to protect the rights and dignity of the vulnerable. Back in India's courtrooms, questions of accountability, constitutional institutions, civil liberties and environmental protection took center stage. So, let's begin. Our first story is in the Madras High Court, where former Tamil Nadu Minister V. Senthil Balaji has been denied anticipatory bail in a corruption case linked to the state-run liquor corporation TASMAC, or Tamil Nadu State Marketing Corporation Limited. TASMAC is a public sector undertaking owned by the government of Tamil Nadu. Balaji, who is currently the MLA from Coimbatore South, is under investigation in a case registered by the Directorate of Vigilance and Anti-Corruption. The agency alleges that between 2021 and 2025, while serving as Minister for Electricity and later as Minister for Prohibition and Excise, Balaji entered into a criminal conspiracy with 6 others, including private individuals, distillery and brewery companies, transport firms, bottling companies, and certain unidentified public servants associated with TASMAC. According to the prosecution, the conspiracy resulted in criminal breach of trust, forgery, misappropriation of public funds, and corruption, causing substantial loss to the state exchequer. The case has been registered under various provisions of the Indian Penal Code and the Prevention of Corruption Act. Apprehending arrest, Balaji sought anticipatory bail. His counsel, Senior Advocate N.R. Alango, argued that the case was politically motivated and linked to recent political developments in the state. It was also contended that TASMAC functions independently and that the minister had no role in the corporation's tendering process or day-to-day operations, with the alleged conspiracy, if any, involving only the bottling companies. However, the Madras High Court was not persuaded, observing that allegations involving large-scale corruption and financial irregularities. The court held that custodial interrogation was very much necessary to effectively investigate the case. Holding that the gravity of the allegations outweighed the grounds urged for protection from arrest, the High Court dismissed Balaji's anticipatory bail plea. Our second story today comes from the Supreme Court, where the constitutional challenge to the Chief Election Commissioner and other Election Commissioners Appointment Act of 2023 saw an extensive hearing. The petitions challenged the 2023 law, under which the Selection Committee for appointing election commissioners comprises the Prime Minister, a Union Cabinet Minister nominated by the Prime Minister again, and the Leader of the Opposition. The petitioners argued that this gives the executive a decisive majority and undermines the independence of the Election Commission. Before a bench of Justice Dipankar Datta and Justice Satish Chandra Sharma, Solicitor General Tushar Mehta argued that the court could not proceed on the assumption that the Prime Minister or the government would act in bad faith simply because they hold a numerical majority on the selection panel. Attorney General R. Venkatramani also urged the court to refer the matter to a larger constitution bench. Justice Datta, however, clarified that the issue was not about distrust of the Prime Minister, but about maintaining the appearance of institutional fairness. Drawing a parallel with judicial principles, he observed that just as justice must not only be done but also be seen to be done, the same concern arises in the process of appointing election commissioners. Appearing for the petitioners, Advocate Prashant Bhushan, Senior Advocates Gopal Shankar Narayanan, Vijay Hansaria and Shadan Farasat argued that there was no need for a reference to a larger bench. They contended that the Supreme Court's decision in Anup Baranwal had already recognized the need to prevent executive dominance in the appointment process and that the 2023 law effectively recreates the same imbalance. The bench ultimately reserved its order on whether the matter should be referred to a 5-judge constitution bench, while directing all parties to file their written submissions. Our third story today comes from the Supreme Court, which heard a petition raising serious concerns over the use of pellet guns against student protesters during the Cockroach Janata Party's Sansad Chalo March in Delhi. The petition was filed by former IPS officer Yashovardhan Azad, along with Prashant Kumar Singh and Sheikh Irshad Mansoori, who claimed that they were among those injured when the Rapid Action Force allegedly fired pump-action pellet guns during the protest on July 20th. According to the plea, both petitioners suffered multiple pellet injuries and had to undergo surgery to remove the metallic pellets from their bodies. The petition also referred to another injured student, 19-year-old Sahil, and relied on the United Nations 2020 guidance on less lethal weapons, which discourages the use of such weapons for crowd dispersal. Appearing for the petitioners, Advocate Vrinda Grover argued that there was no standing order issued by the Delhi police authorizing the use of pellet guns in such situations. She urged the union government to place any such regulation before the court if it existed. However, a bench comprising Chief Justice Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana observed that the petition in its present form did not directly challenge the police regulations governing the use of pellet guns. Justice Bagchi pointed out that such weapons are permitted in exceptional circumstances under existing regulations, and therefore a blanket direction prohibiting their use could not be issued without first examining the validity of those rules. The bench also observed that while peaceful protests deserve protection, situations on the ground can sometimes escalate unexpectedly, requiring the police to adopt a graded response. The court indicated that the real question would be whether the force used in this particular incident conformed to that graded approach. Solicitor General Tushar Mehta agreed with this submission, stating that law enforcement personnel sometimes have to make split-second operational decisions during public disturbances. The court, however, took note of the petitioner's concerns regarding medical treatment. After it was pointed out that one of the injured protesters was not receiving adequate care, the bench directed the Delhi government to ensure proper medical treatment for both the petitioners and any other persons injured in the incident, while the broader issues raised in the petition remained under consideration. Our fourth story comes from the Karnataka High Court, which has taken up a public interest litigation seeking stronger legal protection for Mullayanagiri Hills, home to Karnataka's highest peak and part of ecologically sensitive Western Ghats. The petition has been filed by the Bhadra Wildlife Conservation Trust and the Wildlife Conservation Action Team, which want the entire 23,000-acre Mullayanagiri Hills region to be declared a conservation reserve under the Wildlife Protection Act 1972. They have also sought the constitution of a statutory management committee, an immediate halt to ongoing construction, and directions restraining further building approvals and tourism-related activities in the area. The petitioners argued that although the state has been issuing draft proposals to notify the reserve since 2019, the extent of the proposed protected area has steadily shrunk from the original 23,000 acres to about 10,000 acres in the latest proposal. They expressed concern that unless the reserve is formally notified, the remaining ecologically sensitive land could also gradually be lost to development. The plea also highlights the environmental consequences of the delay, including increasing construction activity, unregulated tourism, and the risk of landslides. It points out that the region falls within the eco-sensitive zone of the Bhadra Tiger Reserve, which was notified by the Union government in 2016. Hearing the matter, a division bench of Chief Justice Vibhu Bakru and Justice K.S. Hemalekha issued notice on the petition. When the petitioners sought interim directions to halt ongoing activities, the court observed that it would first hear the state's response before considering any interim relief. The matter has now been listed for further hearing on November 4th. Our next story today comes from the Bombay High Court, where an important debate unfolded over the balance between religious practices and environmental protection ahead of the Ganesh festival. The court was hearing a public interest litigation seeking a complete ban on the immersion of plastic of Paris or POP Ganesh and Durga idols in natural water bodies. Opposing the plea, the Akhil Ganpati Utsav Samiti argued that immersing Ganesh idols in rivers, lakes, and the sea is an essential religious practice protected under the constitution. However, a division bench of Justice Ajay Gadkari and Justice Kamal Khata appeared unconvinced. The judges observed that devotees would remain free to install idols of any size and perform all religious rituals, but suggested that instead of immersing large POP idols in natural water bodies, they could undergo a symbolic immersion before being recycled. The bench remarked that such an alternative would not hurt religious sentiments while helping protect the environment for future generations. The court also questioned whether immersion in natural water bodies was in fact an essential religious practice. When the Samiti argued that the Dharma Shastras required immersion, Justice Khata asked the counsel to point out where exactly the scriptures mandated immersion in natural water. The bench even suggested that devotees could retain a larger POP idol for worship and symbolic immersion while immersing a smaller eco-friendly idol instead. Justice Gadkari also reminded the petitioners that constitutional rights are accompanied by fundamental duties, observing that environmental protection cannot be ignored while asserting religious freedoms. The Samiti, on the other hand, argued that the real source of pollution was not the plastic of Paris itself, but the chemical paints used on such idols, and suggested that those paints should instead be prohibited. The matter will now continue to be heard while the Maharashtra government informed the court that it will also hold a meeting to consider Prime Minister Narendra Modi's recent appeal in Mann Ki Baat, urging people to shift from POP idols to eco-friendly alternatives. Our next story today comes from the Supreme Court, where the Chandigarh administration is seeking to revive a criminal case against Punjab Chief Minister Bhagwant Mann and several senior Aam Aadmi Party leaders over a protest held 5 years ago. This case stems from a 2020 protest march against the hike in electricity tariffs. According to the prosecution, the demonstration turned violent, resulting in injuries to police personnel, following which an FIR was registered alleging offences including rioting and unlawful assembly. However, the Punjab and Haryana High Court later quashed the FIR against Mann and the other accused. Challenging that decision, the Chandigarh administration approached the Supreme Court. Appearing for the administration, Additional Solicitor General S.V. Raju argued that the High Court had wrongly concluded that no unlawful assembly could exist in the absence of prohibitory orders under Section 144 of the Code of Criminal Procedure. He submitted that once an unlawful assembly is established, the acts of one member are attributable to the others, even if every individual is not alleged to have committed an overt act. A bench comprising Chief Justice Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana briefly heard the submissions before issuing notice to Bhagwant Mann, Aman Arora, Daljit Singh Cheema, and Maheshinder Singh Grewal. The matter comes against the backdrop of the court's earlier observations in the same proceedings, where it had orally remarked that raising slogans is commonplace in politics, and had also noted that there were no specific allegations that AAP leader Aman Arora had incited violence. The court will now examine whether the High Court was justified in quashing the criminal proceedings. Our next story today comes from the Delhi High Court, which has ruled that while vacant medical seats are undesirable, courts cannot direct that reserved seats be converted into unreserved seats once the counselling process has concluded. The ruling came in a case involving Dr. Aditi Panwar, an unreserved category candidate who had sought admission to the DNB post-diploma radio diagnosis course at General Hospital of Panchkula. The only seat in that course was reserved for OBC candidates. Since no OBC candidate qualified, the seat remained vacant and a single judge had earlier directed that it be de-reserved and allotted to her. However, the matter reached a third judge after a split verdict in appeal. Deciding the reference, Justice Dinesh Mehta held that once the seat matrix is published and candidates have exercised their choices, courts cannot order de-reservation of reserved seats. The court observed that doing so could unfairly prejudice more meritorious candidates who may have already accepted admission elsewhere or pursued other opportunities based on the original seat matrix. At the same time, the court acknowledged that vacant seats amount to a loss of valuable educational resources. It therefore directed the National Board of Examinations in Medical Sciences to evolve a mechanism for future admission cycles. The court held that wherever no candidate from a reserved category qualifies in a particular specialty, the authorities should obtain the necessary approvals and de-reserve such seats before publishing the final seat matrix so that they can be offered to open category candidates during the counselling process itself. With these observations, the court answered the reference in favor of the National Board of Examinations in Medical Sciences, while making clear that although de-reservation may be permissible in appropriate cases, it cannot be ordered after the counselling process has already come to an end. Our next story today comes from the Supreme Court, which has clarified its earlier interim order in the long-running Bhojshala Kamal Maula dispute by identifying a specific plot of land near the disputed complex where members of the Muslim committee may offer Friday namaz. The matter arose after the Madhya Pradesh High Court declared the disputed Bhojshala premises to be a temple. That judgment is currently under challenge before the Supreme Court. While refusing to restore the earlier arrangement at the disputed site, the Supreme Court had previously directed the state to provide an alternative location nearby for Friday prayers. At today's hearing, Senior Advocate Huzaifa Ahmadi, appearing for the Muslim side, submitted that the site identified by the authorities was not truly near the Bhojshala complex, as it was over a kilometer away by road. Referring to a site map, he pointed out that several adjoining parcels of Waqf land were available, with the Mutawalli expressing no objection to their use of offering namaz. Ahmadi also argued that the collector's refusal to allot land closer to the complex on the ground of possible law and order issues was legally untenable. He submitted that the constitutional rights could not be curtailed merely because some groups threatened to oppose prayers near the site. After considering the submissions, a bench comprising Chief Justice of India Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana identified a specific adjoining plot where Friday prayers may be offered between 1 p.m. and 3 p.m., thereby clarifying its earlier interim order while the challenge to the High Court's judgment continues to remain pending before the Supreme Court. Supreme Court. Our next story today comes from the Supreme Court, which has clarified its earlier interim order in the long-running Bhojshala Kamal Maula dispute by identifying a specific plot of land near the disputed complex where members of the Muslim committee may offer Friday namaz. The matter arose after the Madhya Pradesh High Court declared the disputed Bhojshala premises to be a temple. That judgment is currently under challenge before the Supreme Court. We end today's edition with a significant environmental ruling from the Madras High Court, which has recognized the Tamirabarani river as a legal person, holding that no one has the right to pollute it, even while performing religious rituals. A bench of Justice G.R. Swaminathan and Justice B. Pugalenthi clarified that the river was being granted personhood because it is worshipped as a deity by Hindus. The court observed that polluting the river would not only violate environmental laws and the rights of citizens under Article 21, but also the river's own rights as a legal person. At the same time, the bench allowed the immersion of ashes, recognizing the emotional and religious significance of the practice. However, it directed that ashes must be carried only in unfired earthen pots that dissolve naturally in the water, making it clear that clothes, plastic, metal pots, and other materials cannot be dumped into the river. Emphasizing that freedom of religion under Article 25 is subject to public health, the court said protecting nature is also a constitutional duty under Article 51A(g). It directed the district administration to prevent pollution, conduct awareness drives, involve local communities, and take action against those contaminating the river. And that brings us to the end of today's edition of LiveLaw Daily. To dive deeper into any of these stories that we covered today, you'll find links to the full reports in the description box below. For the latest updates from the Supreme Court, High Courts, and legal developments from across the country, visit livelaw.in. Thanks for joining us, and we'll see you tomorrow with more from India's courtrooms.